You old fuck, you don't know what you are talking!
I have presided over this courtroom for 22 years, and in that time I have learned something uncomfortable about power. It does not announce when it has gone too far. It whispers, it convinces, it reassures the person holding it that they are different, that rules are for other men, that consequences are abstract things meant for civilians and criminals, never for those who wear uniforms and make decisions in the dark. Today, I am not addressing a stranger. I am addressing a man who once stood on this very floor and testified under oath, a man whose word I accepted without hesitation, a man whose badge once carried more weight in this county than my gavel ever could. That history matters, not because it excuses what you did, but because it magnifies it. You are here because the authority entrusted to you did not merely fail, it turned inward. It consumed its own limits. You crossed from enforcement into judgment, from protection into punishment, and you did so with absolute certainty that no one would stop you. That certainty is the most damning evidence presented in this court. I want the record to reflect something clearly. This case is not about a single decision made under pressure. It is about a mindset cultivated over years, a belief that experience replaces law, that fear justifies force, that intuition outranks due process. These beliefs did not form overnight, and they did not act alone. If you're liking the case, please subscribe to channel. It helps me more to create such video like this. Thank you. Let begin. You were sworn to uphold the Constitution, not your instincts. You were sworn to protect citizens, not classify them into categories of threat based on convenience, suspicion, or prior reputation. Yet on the night in question, you abandoned restraint and replaced it with certainty, the most dangerous substitute for justice. The court has heard testimony describing what happened. I will not repeat it for drama. I will repeat it for responsibility. You entered a private residence without a warrant. You initiated physical force without immediate threat. You restrained a man who had not resisted arrest. You continued to apply pressure after compliance was achieved. And when it was over, you left him there, injured, bleeding, alive not because of mercy, but because your actions stopped short of fatality by chance alone. You did not call for medical assistance immediately. You did not report the incident accurately. You relied instead on the same thing you had relied on for decades, your position, your reputation, the assumption that your version of events would be accepted as truth. That assumption is why we are here. I have reviewed every argument presented in your defense. I have listened to character witnesses describe your years of service, your sacrifices, your leadership. None of that is false, none of it is irrelevant, and none of it outweighs the fact that the law does not bend based on resume. Experience does not grant immunity, authority does not confer infallibility, and service, no matter how long, does not purchase the right to decide who deserves protection and who does not. You did not make a mistake, you made a choice. And choices, especially those made by men with power, demand consequence. I have asked myself repeatedly whether this courtroom failed you before you failed the law. That is not a question judges are trained to ask, but it is one we must confront when authority collapses from the inside. Systems do not rot loudly, they erode quietly, through deference, through habit, through the slow replacement of scrutiny with trust. For years, your testimony went unchallenged. Your reports were accepted as clean, complete, sufficient. When defense attorneys pushed back, the room deferred to your badge. When citizens complained, the system weighed credibility, and yours always outweighed theirs. That imbalance did not begin with malice, it began with convenience. Courts rely on officers to tell the truth because the alternative is chaos. But reliance becomes dependence when oversight fades, and dependence becomes permission when no one questions the pattern. That is where this case truly begins. Not on the night of the incident, but years earlier, when certainty replaced accountability. You believed you were acting in the interest of safety. That belief was sincere, I do not doubt it. But sincerity is not a legal defense. Many injustices are committed by people who are convinced they are right. History does not lack for men who acted with absolute conviction and devastating consequence. You framed your actions as prevention, as necessity, as a burden carried so others would not have to. But prevention does not excuse violation, and necessity does not erase limits. The law is designed precisely for moments when fear tempts action beyond restraint. The Constitution does not exist for easy cases. It exists for moments like the one you created, when a man with power. What troubles this court most is not that you acted forcefully, it is that you acted conclusively. You decided guilt before process. You decided danger before proof. You decided outcome before authority permitted it. In doing so, you did not protect the law, you replaced it. There is a difference between courage and certainty. Courage allows doubt, certainty eliminates it. And once doubt is gone, there is no room left for restraint. That is when force stops being measured and starts being personal. You did not ask whether you were allowed to do what you did. You asked whether you could get away with it. That distinction matters. It matters because it reveals intent, not as momentary panic, but as settled confidence. The court has heard the argument that your years of service earned you discretion, that your experience allowed you to see threats others could not. But discretion is not unilateral. It exists within boundaries, not beyond them. When discretion becomes self-authorization, it ceases to be lawful. I want to be clear about something that has been implied but not stated directly. This court is not punishing you for being decisive. It is holding you accountable for being unchecked, for operating as though oversight was optional and consequence was theoretical. You were not reckless. Recklessness implies carelessness. What you demonstrated was control, deliberate, intentional, and unrestrained by law. That is far more dangerous. This is the moment where many expect the court to balance scales, to weigh service against harm, to find symmetry between good done and wrong committed. But justice is not an accounting ledger. It does not cancel violations with past virtue. It addresses the violation itself. And the violation here is not only against one man, it is against the principle that no one, not a sheriff, not a judge, not a system, stands above the law they are sworn to uphold. There is a temptation, in cases like this, to focus on outcomes alone, to ask whether the man you confronted survived, whether he recovered, whether life eventually returned to some version of normal. That temptation is convenient because it narrows the damage to what can be measured, documented, filed away. But the law is not blind to what lingers after the bruises fade. The victim in this case did not scream in this courtroom. He did not perform his pain. He spoke quietly, cautiously, as someone who learned that raising his voice only invites punishment. That restraint should not be mistaken for absence of harm. Silence in these cases is not peace, it is adaptation. You did not merely injure a body, you altered a relationship between a citizen and the system meant to protect him. You taught him in a single night that compliance does not guarantee safety, that innocence does not guarantee restraint, and that authority does not require justification when it believes itself righteous. That lesson cannot be undone by verdict or sentence. You may argue that fear is an unavoidable byproduct of enforcement, that discomfort is the price of order. But fear imposed unlawfully is not collateral, it is corrosive. It spreads beyond the individual. It settles into communities. It reshapes behavior. It teaches people not how to obey the law, but how to avoid those who claim to represent it. This court must consider not only what happened, but what was signaled. When a sheriff acts without warrant, without restraint, and without consequence, the message is not safety. It is warning, a warning that rights exist conditionally and that protection is selective. I have reviewed your record, commendations, letters of praise, testimonials from colleagues who trusted you with their lives. Those records speak to competence. They do not speak to judgment. And judgment is what failed here. You did not stumble into misconduct. You walked into it with confidence earned through years of unchallenged authority. That confidence insulated you from hesitation. It told you that even if you crossed a line, the system would bend to accommodate you. That belief was not irrational. It was learned. That is the uncomfortable truth this court must face. You were not an anomaly. You were an endpoint of deference unexamined, of power normalized, of accountability postponed because it was inconvenient. You did what you did because, until that night, nothing suggested you couldn't. Some will say this ruling risks undermining law enforcement morale, that holding a sheriff accountable sends the wrong message. I reject that premise entirely. The wrong message is silence. The wrong message is exemption. The wrong message is allowing authority to operate without consequence and calling it stability. Morale built on immunity is not morale, it is entitlement. The law does not weaken when it disciplines its own, it weakens when it refuses to. This court is not blind to the cost of this decision. Careers end here, reputations collapse, families bear consequences they did not earn. Those realities are tragic, they are also irrelevant. The law cannot protect one family by sacrificing another's rights. You were trusted to carry power carefully. You carried it confidently instead. That difference matters more than intent, more than history, more than service. Because when power is misused, it does not matter how many times it was used correctly before. The damage is done in the moment restraint is abandoned, and restraint is the very thing that separates enforcement from domination. There is a point in every case where the court must decide whether mercy serves justice or merely delays its erosion. Mercy is not weakness, but it is not automatic. It must be earned through accountability, not requested through reputation. In this courtroom, mercy follows responsibility. It does not replace it. You have asked through counsel for consideration, for understanding, for recognition of your years of service. I have considered all of it. I have weighed it carefully, and I have reached a conclusion that may feel harsh, but is necessary. Leniency here would not be compassion, it would be permission. The law cannot afford permission when authority has already proven willing to exceed its limits. Punishment is not about retribution, it is about boundaries. It is the clearest language the justice system has when words have already failed. When warnings were unnecessary because no one believed consequences would arrive. When the system itself must speak plainly. This court does not sentence in anger. It sentences in recognition. Recognition that precedent matters more than personality, that future cases will look back at this moment and ask what line was drawn and whether it was visible enough to stop the next man from crossing it. If this court treats your actions as an exception, it invites repetition. If it frames them as understandable, it encourages imitation. Authority watches how authority is handled. That is an unspoken truth, but a powerful one. You were not confused about your power, you were comfortable with it, and comfort, when left unchecked, becomes entitlement. That entitlement manifested not as chaos, but as confidence, the most dangerous form of misuse because it feels justified. Some will say the sentence should reflect balance, that your past good should soften present consequence, but the law is not a scale with nostalgia on one side and harm on the other. It is a line, and once crossed, the response must be clear. This court is not erasing your service. History will record it, but history will also record this moment, the moment when service was not enough to outweigh violation, when authority was not enough to excuse harm, when a uniform did not shield accountability. You stand here not as a symbol, but as a standard, not because you sought that role, but because your position placed you there. The higher the authority, the clearer the consequence must be when it fails. There is no satisfaction in this ruling, no triumph, only necessity, the necessity of reminding this courtroom, this county, and this system that the law is not aspirational. It is binding, binding on citizens, binding on officers, binding on judges, including me. Because if I allow the past to excuse the present, I become complicit in the future, and this court will not trade tomorrow's injustice for today's comfort. Before I render judgment, I must address something that has lingered beneath every argument in this case: legacy. Not the legacy you intended to leave, but the one that emerges when intention collides with consequence. Legacy is not authored by how long one serves, but by how one behaves when restraint is hardest. You believed your career insulated you from scrutiny. That belief was reinforced over time, not by malice, but by silence, by a system that trusted without verifying, by a court, including this one, that assumed experience equaled judgment. That assumption ends here. This ruling is not an indictment of law enforcement. It is a correction within it. Institutions do not survive by pretending their failures are rare. They survive by confronting them when they occur. Today, this court confronts one plainly. You will hear others say this outcome was inevitable, that the moment authority exceeds its mandate, consequence must follow. They are correct. But inevitability does not make this easy. It makes it necessary. And necessity, not outrage, is what guides this decision. You had options, you had time, you had alternatives that the law explicitly provides. You rejected them not because they were unavailable, but because you no longer believed you needed them. That belief is the core violation here. Not force alone, not error alone, but certainty without permission. The sentence imposed by this court reflects the gravity of that certainty. It reflects the harm done, the trust broken, and the precedent required to prevent recurrence. It is not symbolic, it is functional. It exists to draw a line that was blurred for too long. You will live with this judgment. So will this community. So will the system that allowed your authority to grow without sufficient question. That shared burden is the cost of delayed accountability. Let the record show that this court does not celebrate this outcome, it accepts it. Justice is not about satisfaction, it is about alignment, aligning power with limits, authority with oversight, and service with responsibility. This case will be cited, it will be debated, it will be criticized by those who believe accountability weakens order. They are wrong. Accountability is what gives order legitimacy. Without it, authority becomes fear wearing a uniform. I say this now not as condemnation, but as final clarity. The law does not ask whether you believed you were right. It asks whether you were allowed to do what you did. You were not. That is where this case ends. Court is adjourned.